Hi, everyone. Good evening. Carl Steinbeck here. We have second day of testimony from Aperture's expert, Shannon Burgess, continuing on cross-examination today. So let's go ahead and jump right into that. Here we go.
So I'll remind you, you're still under oath. Thank you.
Good morning.
Good morning.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Morning, Mr. Burgess.
Morning.
On your direct examination yesterday, your experience was brought up in questions, correct?
Correct.
On your direct examination, your certifications were brought up in questions, correct?
Incorrect.
There was no discussion in your direct examination about having certifications in Celebrite and Magnet Forensic Axiom. Did I mishear that?
No, if I misheard your question, it was
I asked about certifications. I'll repeat it, sir,
Sure.
in case I misspoke. On your direct examination, your certifications were brought up in questions, correct?
yes, correct.
However, on your direct examination, no questions were asked of you at all about your supposed education, correct?
Correct.
And you did not bring up your educational background at all on
Correct.
direct examination, correct?
Correct.
A forensic examiner must prioritize accuracy, correct?
Correct.
A forensic examiner must prioritize reliability, correct?
Correct.
Both are important.
Correct.
It's criminal proceeding we're in, correct?
Correct.
And therefore, accuracy and reliability are especially important in a criminal case as opposed to a civil case, correct?
I think they would be equally important in both, but yes.
Oh, equally important. So somebody spending their life in jail versus some insurance company losing out some money is equally serious to you. I think that's why he had no qualms about having a bogus resume. He kept on updating bogus degrees and degree dates and the name of the degree he's pursuing and all that kind of stuff. So we'll talk more about that here.
But they're certainly important in a criminal case.
Correct.
And accuracy and reliability are especially important when seconds and minutes matter as they matter and as you testify to in this case, correct?
Correct.
You testified yesterday that the events on the timeline contained in your PowerPoint presentation that was displayed yesterday and presented to the jury were accurate, your words several times, down to the second, correct?
Correct. For the Lexus, yes.
For the Lexus.
Yes.
You said they were accurate down to the second, correct?
Correct.
Let's take a look at your PowerPoint presentation that you discussed extensively before the jury yesterday. Mr. Wool, could we please bring up slide 32 of the presentation Mr. Burgess discussed with the jury yesterday? And Your Honor, with your permission to publish.
Okay.
Thank you. Mr. Burgess, pick your screen.
Sure.
Is this a true and accurate representation of your analysis of Miss Reed's Lexus vehicle traveling to 34 Fairview Road and the O'Keefe residence?
Yes.
According to your timeline, Miss Reed's vehicle powered on at 12:36 a.m. on January 30th, correct?
Correct.
Now, is your timeline on this slide accurate down to the second, as you stated in your direct examination yesterday?
For the power on and off events, yes.
Yes. Could we go to slide 33, please, Mr. Wolk? And we're going to go through a handful of slides,
Sure.
Mr. Burgess, to just give you a heads up. Is this a true and accurate representation of your analysis of Ms. Reed leaving the O'Keefe's residence at 5:07 a.m.?
Yes, it is.
And according to your timeline, Ms. Reed powered on her vehicle at 5:07:46 a.m. on January 30th, 2022, correct?
Correct.
Is the time on this slide accurate down to the second, as you stated in your direct examination yesterday?
Yes, according to the Lexus, yes.
If we could go, Mr. Woke, to slide 34, please. And these are all your slides, correct, sir?
Correct, they
You
are.
prepared them?
Yes.
Is slide 34 a true and accurate representation of your analysis of Ms. Reed traveling to the Dighton residence at 12:25:01 a.m.? I'm sorry, 12:25:01 p.m.
12:35:01. Correct.
I'm sorry. Thank
Yes.
you. 12:35. And according to your analysis, Ms. Reed powered on her vehicle to travel to Dighton at 12:35:01 p.m. on January 30th, correct?
Yes, that's correct.
And is the time on this slide accurate down to the second, as you stated in your direct examination yesterday?
Yes.
Slide 35, please, Mr. Wolf. Is this a true and accurate representation of your analysis of Ms. Reed's vehicle being towed by the Massachusetts police vendor from her parents' residence in Dighton?
Yes, it is.
And pursuant to your timeline that you created here, Ms. Reed's vehicle was powered on at 4:11 p.m. on January 30th, 2022, and towed to the Canton Police Department, correct?
Correct.
Is your timeline on this slide accurate down to the second, as you stated in your direct examination yesterday?
Yes, this timestamp is.
Slide 36, please, Mr. Wolf. Is slide
Yeah, this is C-Star. You're saying you have trouble with all the times, understanding what both sides are trying to say. You do get the big picture. I mean, I keep thinking about
36 a true and accurate
different situations
representation of your analysis of
I'll
Ms.
try my
Reed's
phone
vehicle arriving at the Canton Police?
in the keyboard here. I keep thinking about different ways you cannot trust computers, including car computers. And I remember talking to somebody last year. They had a brand new all electric vehicle, and it kept on shutting off when they're going down the highway and leaving them stranded. And then they'd take it to the dealership. And this is like a brand new $60,000 car. They could take it to dealership. They check it out and says everything's fine. All the computer diagnostics say it's running fine, and then it would keep on happening multiple times. So just cars, especially European cars, I notice have a lot of electronic problems. So not so much with the Japanese cars like the Lexus, but even the Lexus is probably not made in Japan. It's probably made somewhere else, like Canada or something. So anyway, I just think if people are going to like think of this as being like absolute true science of being able to confirm, have confirmation and be 100% absolute, it's accurate where you can convict people. I just don't think that's ever the case. Yet people like this guy have no qualms about making it out to sound that way, like it's good to go, rock solid. You can bank on it. And I'm just saying you cannot bank on any of this stuff. And there is variance in everything. There's constant computer glitches especially in vehicles from what I've seen, like I say. So anyway, just want to throw that out there.
Police department.
Yes, it is.
And pursuant to the timeline you created, Miss Reed's vehicle powered off at 5:36:42 p.m. on January 30th, 2022, correct?
Objection. Objection.
I'll let you have this.
Okay. Is your analysis down to, is your analysis on slide 36 accurate down to the second as you stated in your direct examination yesterday?
Yes, according to the Lexus, yes.
According to the Lexus.
Yes.
In point of fact, Mr. Burgess, none of the 5 timelines that we just reviewed from your presentation are accurate at all, and certainly not down to the second. Am I right or am I wrong?
You are wrong.
Are you aware, and if we could go back to the first slide, which is slide 32, and we'll look at each of them quickly.
Sure.
Are you aware that all of the relevant events in the timeline you described in your presentation in these slides actually occurred on January 29th, 2022, not January 30th, 2022. Do you know that?
This is January 30th, 2022.
That's what
January 29th, correct.
It's January 29th, 2022. And in terms of January 30th, I want to go back and make sure it's very, very clear. In your presentation, they actually occurred on January 29th, 2022, correct?
The night of the incident, yes.
Can I have a moment, Your Honor, please?
Yes.
Thank you. Mr. Burgess, once that timeline crosses into midnight, it's January 30th, not January 29th, correct?
Correct. Yes, it is January 30th. Yes.
So in actuality, these 5 timelines, as you testified to them yesterday, are not accurate down to the second, correct? Because you got the wrong date.
Well, parlance, yes, but yes, they are still accurate to the second.
But the date, these 5 timelines, let's pursue this. These 5 timelines are exactly 24 hours off from the time where the event actually occurred, correct?
No. So these events occurred on January 30th. If I misspoke and said the 29th, yes.
Okay. You understand my point?
Yes, I do.
The core basis of your job, your role in this case, is to reconcile time discrepancies, as you say, down to the second, correct?
Correct.
But your discussion of the timeline on each of these slides, on each of these key events, is incorrect, correct?
No, it's not incorrect.
So your discussion of the applicable date, you're saying, as you described it yesterday and interpreted this timeline, was correct? Is that what you're saying now?
This timeline is correct.
But
Yes.
my question is your discussion of it yesterday.
If I misspoke and said the 29th, then yes, I misspoke on that. Yes.
And that was your testimony yesterday, what you spoke about.
Yes.
Wrong day.
let's turn to a different topic. Lights up, if we could, and thank you for taking that down, Mr. Wolf. Your actually, to mitigate the inconsistencies that you analyzed yesterday between independent clocks, am I correct that your position is that forensic methodology recommends cross-referencing timestamps from multiple sources to identify discrepancies, and when possible, leveraging time anchors, events that contain both a system timestamp and an external physical event to identify and correct timing discrepancies? Do I have that right?
Yes, you did.
Yesterday, we talked about the scientific method. You recall that, sir?
I do.
And how it's designed to prevent bias from infecting the analysis. You recall that as well?
Yes, I do.
And yesterday, you agreed that experts should never selectively gather and interpret evidence to confirm a pre-existing belief while neglecting evidence that contradicts those beliefs, correct?
Correct.
And doing that is called confirmation bias, which you said you understood yesterday, right?
That is correct.
That would be improper to do that, correct?
Yes.
It would raise the specter, if not the reality, of unreliability if that occurred, correct?
It could, yes.
And it could also lead into errors in forensic analyses, correct?
Correct.
Let's take a look at your January 30th report, sir.
Okay.
And this is your first report, your second report being the May 8th report. In your January 30th report, you did not issue any opinion or conclusion with regard to the timing of what you call the text stream event 11/62/2 in your January 30th report, did you?
No, I did not.
You didn't even mention either the phrase text stream event or the phrase 11/62/2 in your January 30, 2025 report, did you?
No, I did not.
But in that January 30, 2025 report, you did evaluate the variance between the Lexus infotainment system on the one hand and Mr. O'Keefe's iPhone data on the other, correct?
Correct.
In fact, in that report, the January 30th report, you compared the call logs on Ms. Reed's Lexus infotainment system with the call logs on Mr. O'Keefe's iPhone in order to evaluate whether there was a variance, correct?
Correct.
And do I have it correct in your report that it's the position that the timestamp call log data, specifically the recorded calls between Ms. Reed and Mr. O'Keefe, along with the infotainment power event logs, were analyzed for what you called clock skew by cross-referencing them against other independent data sources, right?
No, so that would have been comparing the timestamps from Mr. O'Keefe's iPhone with the timestamps from the defendant's Lexus.
Right.
Correct. Yes.
Yes. Right.
No, Lisa, the feds aren't going to get involved in this just because of a bogus fake resume on a previous court filing. I don't know if that one was criminal or civil either. I think it was a civil one. So no, the feds would not get involved in that just for that. But I think they are watching this case still. And they're going after more corruption there in Massachusetts.
To Ms. Reed's Lexus.
Correct.
And a forensic comparison of these data sets was aimed to identify timestamp discrepancies, correct?
Correct.
To identify potential clock skew, correct?
Correct.
And potential clock drift that could impact event reconstruction, correct?
Correct.
All as stated in your January 30th report, right?
Correct.
Yes, I'm just wondering, did Aperture understand him to actually have his degree? Does his bosses know he's taken 17 years? Why would they allow someone to be posing as an expert that is that non-motivated to get a degree, not even a bachelor's degree? And anyway, I have some more comments on that as we get closer. You're going to see later on, unless he goes back to the resume scam.
Your Honor, may I have this marked as the next exhibit in order for identification?
Yes.
Sure.
The BBB ID.
May I present to the witness, Your Honor?
Yes.
Thank you. Mr. Burgess, I am presenting to you what has been marked as Exhibit BBB for identification. I'd ask you to take a look at it, sir, and then pick your head up when you've had a fair opportunity to take a look at it.
Yeah, I don't know what the judge is doing.
Okay. Sure.
Do you recognize?
I'm sorry. Darn it. I hit the wrong.
30th, 2025.
Lost my spot. Sorry, just accidentally hit the mouse and
The whole report to put it in
Why don't I
context.
see what's happening to the
okay, that's
Yes.
It would raise the specter, if not the reality, of unreliability if that occurred, correct?
It could. Yes.
And so your discussion of the applicable date, you're saying, as you described it yesterday and interpreted this timeline, was correct? Is that what you're saying now?
This timeline is correct.
But
Yes.
my question is your discussion of it yesterday.
If I misspoke and said the 29th, then yes, I misspoke on that. Yes.
And that was your testimony yesterday, what you spoke about.
Yes.
Let's turn to a different topic. Lights up, if we could, and thank you for taking that down, Mr. Wolf. Actually, to mitigate the inconsistencies that you analyzed yesterday between independent clocks, am I correct that your position is that forensic methodology recommends cross-referencing timestamps from multiple sources to identify discrepancies, and when possible, leveraging time anchors, events that contain both a system timestamp and an external physical event to identify and correct timing discrepancies? Do I have that right?
Yes, you did.
Yesterday, we talked about the scientific method. You recall that, sir?
I do.
And how it's designed to prevent bias from infecting the analysis. You recall that as well?
Yes, I do.
And yesterday, you agreed that experts should never selectively gather and interpret evidence to confirm a pre-existing belief while neglecting evidence that contradicts those beliefs, correct?
Correct.
And doing that is called confirmation bias, which you said you understood yesterday, right?
That is correct.
that would be improper to do that, correct?
Yes.
It would,
I really don't think this guy even knows what that means. What do y'all think?
raise the specter, if not the reality, of unreliability if that occurred, correct?
It could, yes.
And it could also lead into errors in forensic analyses, correct?
Correct.
Let's take a look at your January 30th report, sir.
Okay.
And this is your first report, your second report being the May 8th report. In your January 30th report, you did not issue any opinion or conclusion with regard to the timing of what you call the text stream event 1162.2 in your January 30th report, did you?
No, I did not.
You didn't even mention either the phrase text stream event or the phrase 1162.2 in your January 30, 2025 report, did you?
No, I did not.
But in that January 30, 2025 report, you did evaluate the variance between the Lexus infotainment system on the one hand and Mr. O'Keefe's iPhone data on the other, correct?
Correct.
In fact, in that report, the January 30th report, you compared the call logs on Miss Reed's Lexus infotainment system with the call logs on Mr. O'Keefe's iPhone in order to evaluate whether there was a variance, correct?
Correct.
And do I have it correct in your report that it's the position that the timestamp call log data, specifically the recorded calls between Miss Reed and Mr. O'Keefe, along with the infotainment power event logs, were analyzed for what you called clock skew by cross-referencing them against other independent data sources, right?
No, so that would have been comparing the timestamps from Mr. O'Keefe's iPhone with the timestamps from the defendant's Lexus.
Right.
Correct. Yes.
Yes. Right. To Miss Reed's Lexus.
Correct.
And a forensic comparison of these data sets was aimed to identify timestamp discrepancies, correct?
I mean, this guy talking about digital stuff on cars and phones, and I just don't trust him. Would you guys trust him if he was trying to sell you something that's very critical? Would you let a guy like this do anything that's critical to your life? If he was a medical professional and he had some bogus degree certification on his records, would you let him operate on you? Even though he'd operated on other people? Would you trust him to do anything to work on your house, or if he had to do some major repair on a house? Would you trust a guy like this that had a bogus resume? I mean, there's nothing serious in your life that you would trust this guy for with a bogus degree put on his CV.
Correct.
To identify potential clock skew, correct?
Correct.
And potential clock drift that could impact event reconstruction, correct?
Correct.
All is stated in your January 30th report, right?
Correct.
Your Honor, may I have this marked as the next exhibit in order for identification?
Yes.
Sure.
Mhm.
Exhibit BBB for ID.
May I present to the witness, Your Honor?
Yes.
Thank you. Mr. Burgess, I am presenting to you what has been marked as Exhibit BBB for identification. I'd ask you to take a look at it, sir, and I'd pick your head up when you've had a fair opportunity to take a look at it.
Okay, sure.
Do you recognize that document, sir?
I do.
May we approach, Your Honor?
Yes.
Thank you.
So that's the thing as a trial attorney in a criminal setting here. If you see a guy and he's just blown his credibility to smithereens, then how much you really cross-examine him on the stuff he's supposed to be an expert on when he's imploded on his credentials like that? So do you just ignore it and just argue that this guy is not even worthy of having any credibility, or do you go ahead and treat him as if he does have those credentials? So they're taking the latter approach here to cross-examine him and try to impeach him as if he somewhat is an expert. But anyway, it's just a different preference of style. I think it's probably better to still go ahead through the cross-examination here because he's still getting tripped up. He's still looking like he doesn't know what he's talking about. And the fact that he's been talking to Tully and Brennan and then changes his report on his own initiative is just so much another thing that's just coming across like it's not credible at all. No expert's going to create a new report without first talking to the person that hired him.
What do you recognize that document to be, sir?
Sure. So this is a graph that I put together that is comparing timestamps, call timestamps from the infotainment module with Mr. O'Keefe's iPhone.
And is that Exhibit BBB for identification in your January 30, 2025 report?
Yes, it is.
And did you create that chart that is depicted in Exhibit BBB for identification?
Yes, I did.
And is that a fair and accurate representation of the information?
I mean, think about it. There's lies told by almost every one of the prosecution witnesses so far. None of these people are going to get prosecuted for perjury. It's just day in, day out lying nonstop. And the prosecutor is the one that has that discretion. But they're happy these people are testifying and willing to respond to their subpoena requests. And so even if they mess it up and tell things that aren't truthful, the overall point they're trying to make is still coming across, and they're hoping the jury buys it.
That you discussed in page 33 of your January 30, 2025 report.
Yes, it is.
I offer Exhibit BBB for identification into evidence, Your Honor.
If we can introduce the whole report to put it in
Why don't I
context.
see what's happening to the floor?
All right, so you guys don't trust him either. So like I say, all this technical stuff, is the jury really following it? I understand all the jurors are taking pretty good notes except for one. Let's jump ahead here. I wonder if they've done anything about her rolling her eyes and making those snide faces to Karen and the defense team.
May I continue, Your Honor?
Yes.
Thank you. Your Honor, at this time, I offer Exhibit BBB into evidence.
Okay.
Exhibit 189.
Thank you.
They represented to the witness, Your Honor.
Yes.
Thank you. Mr. Burgess, I am represented to you what is now Exhibit 189 in evidence. ask you to once again take a look at it, and if you need further time, please take it, sir, and then pick up your head when you've had a fair opportunity to look at that document.
Okay.
Despite claiming the purpose in your January 30 report of, quote, identifying timestamp discrepancies, potential clock skew, and clock drift, you did not compare the time of the 3-point turn between the infotainment system in the Lexus SUV and Mr. O'Keefe's phone, did you?
Not at that time, no.
Instead, you identified the potential variance by analyzing various calls on the infotainment system of the Lexus versus Mr. O'Keefe's phone, correct?
Correct.
This data in that exhibit captures a precise moment in time that is easily compared between the two devices, correct?
Correct, it does.
Mr. Wolk, Your Honor, may Mr. Wolk please publish this exhibit?
Okay.
I don't know that defense has done anything about the code being done with this judge and the prosecutor. I don't know if they just want to ignore it, not raise it, but I sure would be raising it every time it happens. Probably every day I'd have to be raising something about the judge's necessity to be removed from this case.
So this data, just to reestablish, captures a precise moment in time that's easily compared between the two devices, correct?
Correct.
Now, according to your own table, there are potential offsets of reading in the far right-hand column, 2 seconds, 1 second, 2 seconds, 1 second, 8 seconds, 16 seconds, and 21 seconds, correct?
Correct.
And yet, you failed to apply this variance to the infotainment time on the Lexus associated with the text stream event 1162.2, correct?
Correct. May I explain?
I will proceed along. I'm sure if Mr. Brennan has questions and wants you to explain, he may choose to do that. This is simple arithmetic, is it not? It's either an addition or a subtraction, the offset, correct?
Correct.
And yet, in your initial report on January 30th, 2025, you did not take that final analytical step, did you?
No, because these clock variances do not apply to that time frame.
But you didn't take, you know what analytical step I'm talking about, correct?
No, I don't. I don't
All right.
believe so.
We'll come back to it. I want to go focus on your opinion. What you did do, as I understand it, in your January 30th report. So in your opinion, we can leave that up for a moment, please, because I want to see if we need to show the contrast. With your Honor's permission, can we leave it up just a little bit longer?
Yes.
Thank you. In opinion number 5, and please feel free to look at your January 30th report,
Sure.
You indicated only this.
I think Welcher will be pretty soon, yeah. Then sometime this week.
The difference between the Lexus infotainment and Mr. O'Keefe's cell phone ranged between 8 seconds and 16 to 21 seconds during the period between 5:21:36 a.m. and 5:30:31 a.m. on January 29, 2022. Do I have that correct?
Yes, between 5:21 and 5:30 a.m.
Yes. Now what I'd like to do is, and we can take that down. Thank you, Mr. Woke. Let's talk about what information you learned after you issued your January 30, 2025 report. Or at the time of that report, you received and reviewed a copy of a portion of your colleague's slide presentation and report at Aperture, Dr. Judson Welcher, correct?
From a presentation by Mr. DeSogra. Yes.
Well,
Correct.
I understand you want to add Mr. DeSogra. My question
Objection.
is,
Sustained.
okay, yes, Your Honor, thank you. I'm focusing on what would you like to call it? Do you call it a slide presentation you prefer, Dr. Welcher?
Sure. We can.
I want
we can
to
call
use
it-
whatever parlance you're comfortable with.
Yeah, slide's fine. Yeah.
Slide. So the slide presentation of Dr. Welcher that he submitted the same day you submitted your report on January 30, 2025. And in that, he analyzed the timing of the 1162 to what he calls an infotainment event, you call a text stream event, correct?
Well, could I see the slide we're talking about to clarify?
Absolutely. Could we publish what is in evidence? It was 188.
Okay,
And I'm also, may I approach, please?
yes.
At your request, I want to give you
Sure.
that, if we have 188, we'll just give them the actual mark.
I've never seen testimony stricken in its entirety just because they make a false representation on their CV or anything for that matter.
Exhibit.
That's not the remedy. So the remedy is basically charge them with perjury, but even that rarely happens.
You know what we'll do? We'll use the slide. If you need an exhibit, we'll pull the exhibit and move it along. Please publish, Mr. Woke.
Yeah, Peter, I think what happened in the last trial was really that one foreman of the jury was a former cop. And I just know people that are extremely assertive on juries, like a cop would be, they can get them to completely disregard pretty much anything else that's argued in court. They can even tell them, this is not really what the judge means by this. And they can just totally skew everything to their own agenda. So they can really hijack a jury. And so, yeah, it was a freak occurrence. And I cannot believe on a criminal case, a former cop would be allowed by the defense. That's probably the number one person I'd want kicked off. Who knows? Maybe they had worse or something like that, but I would never have a cop on a case where you're accusing your defense's your client got framed. I mean, that's like a no-brainer to me.
Now, if we could enlarge the text, we don't need the map, so make that as large as you can, please, Mr. Wolk, in the relevant portions. All righty. You're aware that according to Dr. Welcher's analysis, as depicted in this slide in evidence, the 1162-2, what he calls an infotainment trigger that you call a text stream event, right?
Correct.
The 1162-2 text stream event occurred at 12:31:38 a.m. on January 29, 2022, correct?
Correct.
And that's when it began, right?
That's when the trigger threshold was met. Yes.
That's when the trigger threshold was met.
correct.
You we can take that down now, Mr. Woke. You also
I think this is just overload for the jury. All this data is just sort of garbage in, garbage out. I don't think it really proves anything. I think the Wi-Fi connection of Karen's phone to John's house at 12:36 pretty much resolves that whole issue. So all the car stuff and Waze and all that other stuff going on here, I just don't think it really matters.
So testified yesterday that you reviewed Mr. Whiffen, Mr. Ian Whiffen's January report, which established a timeline of the last interactive events on Mr. O'Keefe's phone, correct?
Correct.
Your Honor, could we please publish Exhibit 39, which is in evidence?
Okay.
And we could go to slide 82 and have 83 available, if we can enlarge the applicable sections. And what I'm going to ask you, Mr. Burgess, is to see whether these events are consistent with your memory of what the applicable events are. Do you see the column biometric device unlock with Face ID event at 12:32:04 a.m.?
Yes.
Now that's after the 12:31:38 a.m. 11:62:02 text stream event that's in Mr. Welcher's slide, correct, that we just saw?
Correct. The unadjusted Lexus clock. Yes. Timestamp. Yes.
So, but I'm going to repeat the question. The 12:32:04 a.m. device unlock with Face ID event is after the 12:31:38 and 12:31:43 11:62:02 text stream event that is stated in Dr. Welcher's report, correct?
Correct.
Now, do you see the lock event which occurred at 12:32:09?
Yes, I do.
That is also after the 12:31:38 to 12:31:43 text stream event, correct?
Yes, the unadjusted time.
That 12:32:09 a.m. lock event is after the 12:31:38 to 12:31:43 range that is stated in Dr. Welcher's report, correct?
Correct. From the Lexus clock.
So if we could go back, and we're going to toggle back with Your Honor's permission between these two slides for the next couple questions. If we can go back to and enlarge Dr. Welcher's slide. That 12:31:38 to 12:31:43 time period is what your colleague, the licensed engineer, Dr. Welcher, chose and his slide analysis as the last user interaction, according to him, on John O'Keefe's phone, correct? That's what he chose.
Yes, the 12:32:09. Yes.
Now, if we could go back to and zero in, please. Now,
I think because you have younger folks that are techie oriented, I think that can make a difference, and they can follow a lot of this tech stuff more than folks in their 50s, 60s. And so we do have mostly everyone 50 or under, it sounds like, on this jury. So, but the thing is, this has taken so long. It really has taken so long. And to get into all this technical minutia and the court having such short hours, I mean, they don't show up till 9 and they shut down at 4. And with all the breaks going on and the sidebars, you really don't have a single really highly productive day in this court where the judge seems more concerned about coming into work late and going home early than getting this case over and done with. So I think they understand the corruption of the prosecution, and the judge is in cahoots with supporting the prosecution all the way, and they're absolutely fed up with the way this trial is being conducted. So I think they get the main gist of everything, and they should be highly upset that they're having to sit and listen to all these lies and the way the ball's being hid by the prosecution, the judge. I think they're really fed up with it. So I think the defense is winning this all the way so far.
But even Mr. Whiffin's report establishes additional activity on Mr. O'Keefe's phone after the event chosen by Dr. Welcher, correct?
Correct.
And in fact, Mr. Whiffin identifies a quote lock event that occurred 26 seconds after the 11:62 text stream event identified by Dr. Welcher at 12:31:38 to 12:31:43, correct?
Correct. Using the unadjusted clock.
I would like, does Dr. Welcher at all use the words unadjusted clock in his slide, sir?
No. He does not.
Okay, what I'd like to do is ask you a question about whether, in fact, Mr. Whiffin identifies a lock event that occurred 26 seconds after the 11:62 text stream event at 12:31:38 to 12:43, as stated in your colleague's report, Dr. Welcher, the slide presentation. Is that correct?
Yes, that's correct.
Do you know whether a lock event on an iPhone requires human interaction?
Typically, yes, it would.
Is
Typically,
it just typically, or does it?
Well, it does. And in this case
Look-
specifically, I believe it was via the lock button.
look what the judge is doing. You constantly see all this moving around, and she's not doing all that when the prosecution's presenting their case. I haven't seen that kind of movement and activity. How disrespectful can you get?
Correct. But this specific instance, the lock, it requires somebody, a human being, to actually press a button on the side, correct?
Unless it's auto locking, yes, it requires a button press. Yes.
Do you have any reason to believe that the iPhone of Mr. O'Keefe had an auto locking function on it, sir?
No, as I said, he used the lock button.
Right. If we can enlarge that, do you see the end of health event 36 steps that we talked yesterday that was covering a distance of over 84 feet? You see that occurring at 12:32:16 a.m.?
I don't believe we talked about that yesterday, but yes, I do
Do
see
you
that.
see it?
I do. Yes.
And that's also after the 12:31:38 to 12:31:43.
Look at her still moving around. Can't wait till Alessi's done. She's signaling. The way this comes across to a jury, I think they're probably frustrated too. But when a judge is moving around that much, it's basically just sending the message that this is not worth listening to. You need to move on. I'm tired of hearing you, defense counsel. You're not making any points with me.
Text stream event identified by your colleague, the licensed engineer, Dr. Welcher.
No, of course, Ruth Markel did not make any faces. They just sat there very stoically and politely, utmost professionals you can imagine. So I don't, no way did you see any of that kind of behavior out of her or Dan Markel's father, Phil Markel. I mean, I saw him down there. I was there for closing with John, and we never saw anything that was anything but the utmost professional. In fact, after the verdict came out, Phil even told the local media there that he was thankful that there was a good defense put on by Charlie. So, I mean, that's a kind of dignified gentleman he is. So all these kind of snide faces and remarks that Peggy O'Keefe is giving is really, really not helpful and should be shut down by the judge. The judge should be able to pick up on that if the defense isn't. But this is something that has gone on way too long here.
In his slide, correct?
Correct.
Now, finally, do you see the entry pocket state detected at 12:33:14 a.m.? You see that, sir?
Objection.
Sustained.
Do you know what a pocket state is, sir?
I do know what a pocket state is.
Do you know when the pocket states occurred on the iPhone of John O'Keefe pursuant to your analysis of his phone?
I do not.
Look at her moving around.
You didn't analyze pocket state detections on Mr. O'Keefe's phone?
No, I did not personally.
So if the jury's looking at him, they constantly see the judge moving around, fidgeting. I mean, just how unprofessional.
Do you believe pocket state detected data? Well, let me just go back and confirm. So you didn't analyze with any source pocket state detection information with regard to Mr. O'Keefe's phone. Is that correct?
That's correct.
So let's go back and summarize for each of the ones you did look at and analyze that you just testified. Every single one of those that we just discussed, those user interaction events, occurred after Dr. Welcher claims a collision occurred as represented in a text stream event of 11:62:2 at 12:31:38 to 12:31:43, correct?
Objection.
Sustained.
Do you understand? Let's, if we can go back, please, to Dr. Welcher's slide. Highlight the text again, please, Mr. Wolf. Do you understand that
Love free.
Dr. Welcher is correlating the infotainment trigger 11:62:2 with an alleged collision? Do you understand that?
Objection.
Let's come to side back, please.
Again, truth blocking here. Let's jump ahead. I think this is the 101. They have a sidebar for like 6 minutes. I mean, what a waste of time. So I'm going to jump ahead to 107.
You can put it back up.
Thank you, Your Honor. If we could go now, Mr. Woke, back to the slide from Dr. Welcher's slide presentation.
I like what he's doing. He's basically pitting the two aperture experts against each other and highlighting things that don't make sense and don't add up.
And if you could re-enlarge the applicable section that we've had up before. Thanks for your patience,
Sure.
Mr. Burgess.
How does John O'Keefe shut off his phone if he's mortally wounded and about to instantly die, or within minutes or a brief period before he's dying? He's really going to be worried about shutting off his phone. If anything, he'd be trying to call out if he had that kind of dexterity. to use his phone. Call 911 or something like that.
You have reviewed this slide and this specific data in this slide previously, correct?
Correct.
And I just want to, Mr. Wolk, just go back to the slide so we're clear on what this is. So this slide here is what you're speaking about, right?
Correct.
And you've reviewed this slide prior to your testimony in this court, correct?
Correct.
And you considered this slide as part of your analyses that you have performed and testified about, correct?
Yes, I have.
So now, Mr. Burgess, I'd like to ask you a question. Every single one of the user interaction events that we talked about, steps, lock, etc., occurred after Dr. Welcher's, what he calls an infotainment event, which you call a text stream event, in the range of 12:31:38 to 12:31:43, correct?
I would agree that yes.
So the answer is yes?
With the caveat.
I'm sorry, I didn't know
Sorry.
you hadn't finished.
Sure.
Please finish your answer.
Yes, with the caveat that user interaction only applies to the device lock, steps, and the pocket state are not duplicative of user interaction per se.
Let's just assume that is the case. Let's then just focus on what you consider to be a user interaction, which is device lock, correct?
Correct.
And the device lock event that you agree is a user interaction. We could go back to that just so we have clarity. The lock event that you agree is a user interaction occurred at 12:32:09, according to Mr. O'Keefe's phone, correct?
Correct.
In that 12:32:09 time period, we could go back to Dr. Welcher, it is after the end of the text stream event dubbed as 11:62:2, correct?
Correct. According
And that's
sorry.
26 seconds. I didn't finish my question. I'm sorry, Your Honor.
So go ahead, finish your question. Don't answer, Mr. Burgess, until the complete question.
In that event lock, even according to Dr. Welcher's own words in his own slide,
That's true, James.
occurs 20 seconds after the end of the text stream event 11:62:2, correct?
of the unadjusted clock, yes.
May I have a moment, Your Honor?
Yes, do you want the lights on, Mr. Leslie?
And so to repeat to alter it, hopefully make it a little clearer. So according to Dr. Welcher, the licensed engineers, your colleague at Aperture, his slide that he has here, the last O'Keefe cell phone event, the lock, occurred within approximately 26 seconds after the end of the text stream event dubbed 11:62:2. That's what's stated there, correct?
Correct. According to the unadjusted clock.
You keep adding according to the unadjusted clock, but do the words according to the unadjusted clock appear anywhere in that slide, sir?
No, they do not.
We can take that down and, with the court's permission, turn the lights back on, please. Yesterday, you stated that you reviewed a presentation by another expert, Mr. DeSogra, who reviewed the findings of your January 30th report. Do you recall that, sir?
Yes, I do.
In fact, in your May 8, 2025 report, your second report, your first being the January 30th report, you only cite 2 new sources of data that you reviewed before making your conclusions, correct?
Correct.
We have a moment, Your Honor.
Yes.
Look at her. Why didn't you get a better chair? If she's out uncomfortable, she constantly needs to be
heard on this.
moving around in her chair, swiveling. All right, let's jump ahead. More sidebar wasting.
Yes.
Thank you.
Sure.
I'm going to present to you 2 documents, each of which is marked for identification. The first is Exhibit CCC for identification. That is one slide out of what is marked as Exhibit DDD for identification. And Exhibit CCC is 1 page out of
That's
Exhibit
did not know
DDD
that.
for identification. And I'd ask you, sir, to take a look at those documents and reference either one. And please let me know, sir, when you've had a fair opportunity to review those documents so I can proceed with questions about them.
Sure. Okay.
Sir, can you please read the exhibit designation on the entire slide presentation?
On DDD.
Pardon me?
On exhibit DDD.
And that's triple D as in David.
Correct.
So in exhibit DDD, is that the March 5, 2005 PowerPoint presentation?
I'd go a little bit faster in my speaking if I was Alessi here, because you're going over some minutia details, and so I think you got to keep more of a higher op tempo when you're going through these kind of minute details.
Of Mr. DeSogra that you spoke about extensively yesterday.
Yes, it is.
And sir, before you came to court yesterday, did you review and consider the exhibit DDD for identification?
Yes, I did.
And as a matter of fact, you spent considerable time with regard to exhibit DDD before you came to court yesterday.
Correct.
And in addition, isn't it the case that your testimony yesterday is that exhibit DDD, the March 5, 2025 slide presentation? That's
what I'm thinking. Alessi, he's so convincing with the way he speaks, but he can talk too slow. And think about it, when he was on this guy's resume fiasco, he was talking a lot faster, louder, and aggressive, and now he's sort of like more in a slower mode. And so if he was going to do a closing in the slow mode, I would rather have Jackson do it. But if he's going to do that more of an op tempo speed, I think I can see Alessi really being the best option they have for doing a closing.
Presentation of Mr. DeSogra was part of the reason why you created your May 8th, 2025 report, correct?
Correct.
May I approach, Your Honor?
Yes.
Your Honor, I offer Exhibit Exhibit CCC into evidence, and do not offer Exhibit DDD at this time.
Okay, the witness just spoke of DDD, so why don't you have him just say what CCC is before we put it in?
I will do so, Your Honor. Thank you. Mr. Burgess, is Exhibit CCC a slide page out of Exhibit DDD?
Yes, it is.
Okay, now it'll,
Thank you for that, Your Honor. I now offer Exhibit CC.
Yeah, they're all likable, and I think the jury is feeling sympathetic the way they're being stonewalled from presenting truth.
CC for identification into evidence.
yes.
Thank you. And I also hand back to Madam Court Reporter Exhibit DDD for identification.
Exhibit 190.
Yeah, I mean, if they sent this case to jury right now, she should come back not guilty across the board.
And sir, do you have before you read the three letters, please, just so we're on the same page in that exhibit?
Jim, we need the
That
other
the
one.
one that's in
Thank you.
the one page?
Yes. Exhibit 190.
And that's the entitled All Possible Combinations?
Yes, it is.
So we'll refer to that as Exhibit 190, okay?
Okay.
Have you had a fair opportunity to refresh yourself on that one-page chart?
Yes, I have.
Your Honor, may I please publish Exhibit 190?
Yes.
And if we could enlarge it without, I think, Mr. Wolk, we can obscure for the moment the all positive on the right and come back to that as needed.
Yeah, that's a good point. All right, I will do that. Thanks for reminding me.
Thank you. Now, Mr. DeSogra, who is an expert for the defense, took
There you
the
go.
data points you evaluated in your January 30, 2025 report and simply performed the last step in your analysis that I was referring to in previous slides, correct?
Correct. For a lot of data points that do not apply for the time of the accident.
I understand you may have a view as to whether they apply or not. I'm just trying to understand
Objection.
what you understood he did.
Again,
I'll
we'll-
repeat that. Yes,
so
Your
we'll
Honor.
strike the comment part and just a
I'll
question,
repeat and
please.
just go to the question. So you understand that Mr. DeSogra took the data points that you evaluated in your January 30, 2025 report and simply performed the last step in your analysis, correct?
In my report, in addition to Dr. Welcher's.
Right. In addition to that.
Correct.
Now, what I want to do is just elucidate.
All right, that's not true, Jenny B. And I'll talk about that. I think Friday, since there's no court on Friday, I'll show some clips of some other attorneys saying what a great job prosecution is doing. So we can talk about it then.
The columns and their meaning. So the column on the right equals the number of seconds, and it's the far right, the number of seconds between the end of the 11:62:2 text stream event that in the slide of Dr. Welcher is ending at 12:31:43 and the lock event on Mr. O'Keefe's phone that's occurred at 12:32:09, correct?
Correct.
And that's your understanding of that column as well.
Correct.
Now, even taking your colleague Dr. Welcher's assumption that the last user interaction on Mr. O'Keefe's phone occurred at 12:32:09 a.m. on January 29, 2022, is Mr. DeSogra demonstrating in this chart that by using the clock variance that you calculated in your January 30 report, there are no circumstances where the trigger event of 1162-2 occurs before the lock event on Mr. O'Keefe's phone.
Objection.
After.
Sustain, there's one part of your question that needs to
Okay.
be omitted.
Yeah, I agree. They're much better.
In terms of this chart, do you agree that the methodology and application of it of Mr. DeSogra is that Mr. DeSogra took the last user interaction data point of Dr. Welcher in his slide of 12/32/09 and applied the clock variance that you calculated in your January 30th report? Do you agree that that's what Mr. DeSogra did?
No, I do not.
What do you believe Mr. DeSogra did here?
Well, so the math is correct. So when he's trying to adjust clock variances between the two devices, that math is correct, but he's applying incorrect adjustments.
I understand, but what I'm trying to get at is just what you understood Mr. DeSogra did in this chart.
Correct. I did understand, yes, what he
Okay.
was trying to do.
And so do you agree, based upon what Mr. DeSogra did as represented in this chart, there are no circumstances where the 1162-2 text stream event occurs? Well, let me have you describe what you believe Mr. DeSogra is doing with regard to comparing.
I think my strategy would be like this stuff is not, like I say, rock solid type of data. There's always variances and glitches and all that kind of stuff. The one that matters the most is a Wi-Fi connection with Karen's phone, and that's something that should be more credible than all this other car stuff and the wave type data from that app. And I think the Apple Health data, I think him taking steps up and down flights of stairs, I think that kind of stuff is helpful. So if it helps somebody, I think it's more credible. But if you're going to like convict somebody based on that, I think it's not credible. Also, I think spending this much time on this kind of data, I think is I'd be shorter and crisper and more to the point on if this was my case in Texas. So let's see. So this goes on till hour 52. So yeah, that's almost another 25 minutes. So what we did have here, though, is Burgess did admit that all this infotainment triggers in Alexis are not necessarily collisions. There are many things that they can represent. So they can't even say that there was a collision, even though we're going over all this data. And so if we can't even say it's a collision, I think it's just spending too much time. So I'm just going to jump ahead. So they go to 152, take a sidebar, and then at 2 hours to 2 hours 9 minutes. They have a morning recess. Let's see. It's right here's a morning recess. And let me see here. And then let's see here.
Are you aware that there were approximately 30 text stream trigger events in an 8-month period on Ms. Reed's vehicle?
No, I'm not.
30 and 8-month period. So it's not every day, but they're frequent.
Assume the data shows that in the mere 8-month period that Ms. Reed owned her vehicle, the Lexus in question, there were 30 text stream trigger events. Assume that. You would not conclude that there were 30 collisions in that 8-month period, would you?
No, I would not.
Would you agree, sir, that there were actually 2 triggers on January 29th?
Yes.
And the first trigger that you referred to of 1162-1 That was not a collision, was it, sir?
Without reviewing the data, I don't know.
Well, as you sit here today, you have no basis to state that the 1162-1 trigger was a collision, do you?
No, I do not.
And in fact, didn't you refer to that as a 3-point turn?
I did, yes.
All right,
And you
I'm
didn't
going to go ahead. Let's see. Why don't we go to the redirect by Brennan? Starts at right there. Brennan starts back up. So Hank tries to clean up this brutal cross. He references all the various certifications that Burgess had that he didn't bring out yesterday. And he basically then does the same thing he always does, rehashes his direct examination and sort of has more of an angry tone.
Are you involved in the website design or content?
No, I'm not.
Do you know if Aperture gets the information from their website directly from LinkedIn?
I don't know where they get all their information from.
Did you ever weigh in or develop your information that was on Aperture's website?
No, not on the website.
Well, the thing I would have fleshed out more, it's like, well, why would it suddenly change? Right before this trial, you suddenly change your resume and now put in the information you need to, which is you have a pending degree. You're pursuing a degree. You're saying pursuing, but we're going to get to that more later. So anyway.
You do provide CVs before you come to court, don't you?
Yes, I do.
In this case, you were asked by the defense, when you provide your CV,
You know what? He's the one sending out. That's the other thing I'd bring up. He's the one sending out a CV every time he's an expert, right? He's not relying on other staffers to send him stuff. They're not going through his central switchboard secretary to send out CVs of their experts. He's sending it directly. So every time there's a bogus CV out there, he's the one sending it to all the folks he's being hired to support.
do you understand that it's going to be reviewed by whoever requests it, the Commonwealth of the Defense,
Yes, I do.
and that it will be shared with both sides in the court?
Yes.
In fact, the first time you provided a CV in this case, was it October 11, 2014?
Objection, Your Honor.
So the leading nature sustained.
Do you remember the first time you provided a CV in this case?
It would have been around October
Of what year?
2024. Sorry.
And when you provided that, was it as an exhibit to something?
Yes, if I recall, it was as an exhibit to the initial protocol that I sent out.
And when you submitted that CV, did you appreciate whether or not it would be part of a court filing in public?
Yes, I did.
If I could have exhibit 183, please.
Yeah, so if he sent it correctly this first time, why is he not checking to see what's on his LinkedIn account and they're on the firm website? Unbelievable that this guy thinks that there wouldn't be cross-reference checking on his resume, that he could update it. Well, this one's making world YouTube coverage. I've never had that kind of exposure on a case before, and if I'm going to testify, then yeah, I better note that I'm pursuing it. So we'll talk about the pursuit term later.
$183. You could enlarge the top section.
Yeah, I agree, Scott. Just start taking too long.
Right there is good. And sir, when you provided this CV to be filed with the court and made public, did you indicate
Yeah, that's true.
that you had obtained a bachelor degree?
No, I did not.
Why did you put currently pursuing?
Because I am currently pursuing a bachelor.
I think he only updated on this case because he knew this was going to be televised to the world. That's my impression.
Bachelor's degree.
And did you understand your CV was received by the defense and they knew this?
Yes, I do understand that.
Subsequently, you were
I mean, the most important thing to have on your resume to be qualified as an expert is your academic credentials. This is the highest one he is representing. And
asked to provide an updated CV in April 2025.
Yes, I was.
Did you do that?
I did.
And can we have exhibit 184?
yeah. So let's look at what Hank isn't asking him. Currently pursuing, right here, see that currently pursuing? why didn't Hank ask him, how is he pursuing this? How do we know he's not been sitting on this thing for 10 years, not taking a single course? Why didn't he ask him to explain, what does he mean by currently pursuing? Yeah. Do you think this guy's really enrolled? If he was really enrolled, he wouldn't be, he would be asked that question. Yeah, I agree with you, Amanda. They didn't ask him enroll. How many courses are you taking? When's the last time you took a course and finished it? Yeah, currently pursuing. I mean, that's such a vague term. Really? Do you really think many people would want this guy as an expert over their other experts if he put down currently pursuing? Yeah, 17 years you're pursuing. No, you're not pursuing if it takes 17 years.
Because I am currently pursuing a bachelor's degree.
And did you understand your CV was received
What's current mean to this guy? In the last 17 years, that's current?
by the defense and they knew this?
Yes, I do understand that.
Subsequently, you were asked to provide an updated CV in April 2025.
Yes, I was.
Did you do that?
I did.
And can we have Exhibit 184?
Yeah, I don't think there's anything in years this guy's done.
Did you further appreciate this would be provided to both the court and the defense?
Yes, I did.
Did you represent to the defense that your education included earning a bachelor degree?
No, I did not.
You've testified in, you can take that down, please. You've testified in many other cases
I have. Yes.
in courts around the country.
Yes, I have.
What resume did you give those courts, those attorneys?
You've testified in other courts around the country. Do you know whether there are transcripts of your actual testimony?
Yes, I believe there are.
Have you ever represented in any court that you achieved your bachelor's degree?
No, I have not.
Have you ever
Oh, is he banking that they're not going to go back and check? Who's got time to go search these things and all that? So
inflated your qualifications in a court?
No, I have not.
When I asked you about some of your background, you told us that you had certificates in Celebrite and Axiom. I didn't go through all of the.
So why didn't you ask him about it? If he had such a clean record on it, Hank, why didn't you ask him about his academic successes, his qualifications? Hank was hoping the defense wouldn't catch this. So you guessed wrong there. Yeah, I agree. This is insulting. He got tipped off. We need some updates. We need to close the window to have things align up properly. All right, so let me go ahead here. I'm going to go up to redirect or recross by Alessi. Let's do that. Up here, I'll jump to 540.
Once we get these marked,
At 547, there's some eye rolling thing going on by the guy up there in front of the judge, apparently.
A, B, and C.
Yeah, Hank talked about other people that didn't have degrees and all that. What's that got to do? They're not lying about their degrees. They're not coming up with bogus CVs or resumes.
all right? Whenever you're ready, Mr. Leslie.
Thank you, Your Honor.
That's interesting.
May I, Your Honor?
Yes.
Thank you. Mr. Burgess, between the time you left the witness stand yesterday until this moment, have you talked to anyone about this case?
No, sir, I have not.
Has a filing
Yeah.
ever been made?
Yeah. Can you imagine that? Gosh, I wish the jurors could see the way Hank Brennan treated those ARCA experts. I don't think he can hold back. I think he's going to be as ugly as he was back then.
In any court in which your educational background has been misrepresented?
No, not that I'm aware of.
Pardon me?
Not that I'm aware of.
Yeah, so he never talked to the Aperture folks, his bosses. He never talked to Wiltshire, really? You just embarrassed yourself on this massive a scale? And Aperture doesn't even do any follow-up with you?
Did I understand that you're based out of the Aperture office in Texas?
Yes, I am.
And are you aware of a case in the United States District Court, Eastern District of Texas, Marshall Division, titled Jeffrey Glover and Teresa Glover versus Graphic Packaging International LLC? Are you familiar with that case?
Yes, I am.
Hey, Nick. Yeah, I do think if there's one that didn't have their mind made up, what can happen though is jurors, when they get together, there's always some folks that they're never going to be, oh yeah, well, I shouldn't say never, but normally they're not going to be 100% unison. So they have to do some discussion on it. So I think if there's one holdout, the one that's not taking notes, I do think that the other jurors will be able to convince them. But if they're willing to really make this thing go into a second mistrial, I just don't think that's going to happen. I think most likely it's going to be not guilty across the board, but in no way can they get a conviction on any of these charges. No way. So, and worst case scenario, I would say it's going to be a mistrial, but I really do think that this should be a not guilty across the board.
And is it correct that in that case, well, tell me how you are participating in that case, sir?
So I'm no longer participating in that case. So if I believe correctly, that would have been a accident reconstruction case from, I don't recall, a year or two ago.
And so it was a case that you did participate in, correct?
Yes, I did.
And what was your role in that case?
Sure. So my role in that case was an accident reconstructionist.
And did you?
Well, these guys, if they're experts, they're probably working from home. So the fact the office is closed, I don't know that really means a whole lot. If it's vacant, I'm not sure. I'll check that out.
Provide any testimony, deposition, or otherwise in that case?
No, I did not.
Did you, in that particular case, there were, like all cases, filings made, correct?
I'm sure there were, yes.
I would say no. I don't think he does at all. Interesting.
May I approach, Your Honor?
Yes.
I would like to have a document marked as the next exhibit for identification,
Okay.
please.
Exhibit EEE for ID.
May I present to the witness, Your Honor?
Yes.
Thank you. Mr. Burgess, I am showing you a document which has been marked as Exhibit EEE for identification, and I'd ask that you take a look at it, sir. Your Honor, may I remain here?
Sure. As
Thank
long as you stand back a little bit.
Exactly, yes. Thank you, Your Honor. I'll make it even farther.
Yes.
Mr. Burgess, with regard to Exhibit EEE, do you recognize the second page, and do you recognize any stamping at the top of each of those pages?
Yes, I do.
And can you describe what that stamping is?
Sure. So that is stamping for a file date of 8/7/2023.
And is that a stamping of a federal court?
That I'm not sure.
If I were to show you a document, might a document refresh your recollection as to whether
Sure.
Exhibit EEE is a filing in a federal court?
Yes.
May I, Your Honor?
Sure.
I am showing you,
Did you show those to Mr. Brennan?
thank you, Your Honor. I believe I did, but I want to make sure.
And just let me know if we need to move.
We will, Your Honor. Can I mark each of
Yes.
these for identification? There,
Yep.
let me just give one first. If I could see that back and court report, I want to see if this is the second page for that document. It is, so it could be marked as one document for identification.
Exhibit FFF for ID.
Thank you.
I reach over you, sir.
Yes.
Thank you. Sir, I am showing you what has been marked as Exhibit FFF for identification and ask whether or not this document can refresh your recollection as to whether the court filing that you reviewed in Exhibit EEE is indeed a federal court.
Yes, it is.
So that document refreshes your recollection that what has been filed is represented in EEE as a filing in a federal court, correct, sir?
Correct.
Now, what I'd like to do is to draw your attention to the second page of this exhibit. Is that a curriculum vitae of you and a picture of you?
Yes, it is.
And sir, under education,
Objection.
I would,
The objection stays.
Well,
do you,
Do you want to bring it over? We can take
I
it
will,
there.
Your Honor, I will.
why is the judge smiling at that? That is so bizarre.
Is that a curriculum
Look at this way she's like looking at Alessi like that, sort of dismissive,
vitae of you and a picture of you?
looking down,
Yes, it is.
fooling
And
around,
sir, under education,
Objection.
swiveling in the chair.
I would,
The objection stays.
Hmm.
do you,
She's so happy that there's finally an objection.
Do you want to bring it over? We can take
I
it
will,
there.
Your Honor, I will.
Jurors, feel free to stand up and stretch.
Okay, so let's go back.
Yes, it is.
So that document refreshes your recollection that what has been filed to that, I would,
The objections stay.
Right. do you,
Do you want to bring it over? We can take
I
it
will,
over.
Your Honor. I will.
All right. Supposedly this court officer is rolling his
Bruce, feel
eyes.
free to stand up and stretch.
I don't see that. Don't see that. Sorry. All right, let's go look at let's jump ahead here. Another sidebar, wasting time. The judge promised the jury there'd be less of these.
For witnesses, are you aware, Jen?
All right, here we go.
Mr. Burgess, I'm going to have to get a little closer in
Sure.
proximity. Bear with me, please. What I would like to do, sir, is to put before you again Exhibit FF for identification and Exhibit EE for identification. And what I would like to do is to ask you some questions, sir, with regard to the process in the case.
Okay.
Are you aware, or do you recall in this litigation that, as typical in litigation, including federal courts, that as part of the litigation process, the parties have to designate their expert witnesses? Are you aware generally of that process?
Generally, yes.
Yes. And have you participated in the documents that need to be prepared for an attorney or a party to prepare documents and submit them to a court to establish the designation of expert witnesses?
No, I have not.
And so you have never participated or never been aware of a process like this?
No, I'm aware of a process, and that process goes through other staff members
Okay, so it goes through other staff members where?
at Aperture.
Right.
Correct.
Are you aware that that process is occurring, even though it may be done by other staff at Aperture?
Yes, I am.
And in this instance,
Funny you mention that, because I think that Welcher coming to testify is got to be something that he's dreading to have to do, and he doesn't have to do it. He could back out. And so why he would agree to testify after having this disaster of a witness represent his company, because he's going to get crossed on this kind of stuff as well. What was he doing to allow this guy to have bogus resumes floating around?
we're aware in this litigation that staff at Aperture needed to submit documents in support of an expert witness designation, correct? Even though you may not have done it yourself, you were aware that some person or persons at Aperture were performing that process, correct?
Correct.
And they were performing that process so that you could be designated as an expert witness in that case, correct?
Correct.
And so you were aware of the process, you were aware they had to submit documents that would establish your qualifications as an expert in the case so that you could be designated as an expert witness, correct?
Correct.
And now specifically with regard to,
Unless he needs to raise his voice, there's not a mic there. He needs to have a loud voice, even if he's close to that close to the witness.
Exhibit EEE for identification with these court filings, etc. Even though you may not have done it yourself, were you aware that this document, which is EEE, was submitted as part of the expert designation process we were talking about?
Not this specific document, no.
Were you aware that a CV was needed to be submitted on your behalf as part of the designation process?
Yes.
So you were aware a CV had to be submitted, but you're saying you don't recall this specific one being submitted?
Correct.
Does the timestamp up at the top of each page of Exhibit EEE, including this page that is your CV, match the timestamp.
Look how
or is
frustrated
it
the judge
different
was
from the
looking.
timestamp at the top of Exhibit FF.
She doesn't like the defense making all these points.
No, that is the same.
So it's exactly the same.
Yes.
And have you been involved in processes in courts where your qualifications, including your CV, have had to be submitted to courts to establish a designation as an expert witness?
Yes.
And can you conclude from these documents, including the timestamps, that the submission that was made to the court to establish your status and as an expert witness consisted of exhibits FFF and EEE?
Objection.
I'm going to allow that. Were you aware of that?
Yes.
Your Honor, at this point, I move EEE and FFF into evidence.
You need one more step, Mr.
And sir, do EEE and FFF fairly and accurately represent the submission of documents in support of a designation of expert witness in this case?
Yes, as far as I can tell.
Your Honor, I offer these two into evidence.
I'm going to allow it over here.
Can I get her briefing?
Yes, come on up. Bring those, please, Mr.
Yes, Your Honor.
Oh, block the truth from coming out again. Prosecution's MO. You're not doing yourself any favors for this jury. I guarantee you that. They're so sick of all these objections from this defense attorney posing as a prosecutor.
I'm going to have to stand here again, Mr.
Sure.
Burgess. So what I would like to do, Your Honor, at this time is to offer into evidence Exhibit EEE and Exhibit FFF for identification
As one exhibit?
as one exhibit.
All right, we'll do that. Madam Clerk, for me.
And that would be the order.
Exhibit 193.
Thank you. May I hand it to the
Yes.
Mr. Burgess, I am handing you, it is now in evidence as Exhibit 193. I would like to draw your attention to the fourth page, which is your CV. And further, if I could, sir, draw your attention to the category of education, where it says BGS. Is it correct that there you state Bachelor of General Science in Mathematics and Business Administration, University of Alabama - Birmingham, Alabama, comma, 2024? Did I read that correctly?
You did read that correctly. And this was
The date keeps moving on when he graduated, 2018, 2022, 2024, depending on when he's sending it to which court.
filed in 2023.
Understood. So now what I'd like to do, Your Honor, is to, may I keep this for a moment, Your Honor, give it to the witness as needed. Thank you. With Your Honor's permission, I would like to publish a document that is already in evidence.
Okay.
Actually, there may be two, 183 and 184. Let's start with 183. Let's expand it. And then, Mr. Wolf, do we have what has just been to publish as well? So what I'd like to do is to publish first, with the court's permission, Exhibit 193 that we were just talking about, so the jury can see what has been the subject of discussion. And sir, if you, Mr. Wolk, if you could just enlarge, all we need is the education section.
Good. I'm glad the jury's
Now-
looking at this.
Mr. Burgess, as I heard it correctly in questions from Mr. Brennan, you answered the question that whether you had ever filed a document that misstated your educational background in a court? Do you recall that question asked of you?
Yes, I
And
did.
your answer was no, correct, sir?
Correct.
So let's look at this document, which we've just gone through, was filed in federal court in the
Remember, he said he never testified in federal court, but I guess he came close to it as maybe an ongoing civil case.
United States District Court, Eastern District of Texas, Marshall Division, which is a federal court. And attached to it is your CV. And in the line of education, it lists under BGS, Bachelor of General Science in Mathematics and Business Administration, University of Alabama, Birmingham, Alabama, 2024. You see that, sir?
I do, yes.
Now, you stated, and now what I'd like to do is is there any qualification whatsoever?
Hey, let's keep the chat clean. Be professional. I don't want to have this degrade into some kind of a smear campaign or unprofessional language. That's I'm not going to get into it. I don't want to see F-bombs and all that kind of stuff. Let's have this clean, professional. And those of you that are new, that's the standard I use here.
In that line, that reference to BGS qualifications at all, explanation, sir? Is there anything?
I don't know what you mean.
It's just a statement.
Of course, you know what he means. Where does it say expected or anticipated or pursuing? He's posing as a graduate, and this was submitted in federal court.
Right? There's words there. There's nothing after it that explains what's intended. Correct?
Right.
Correct.
Now, what I'd like to do, Your Honor, is to go to what was filed in this case, which is in evidence, and we'll go to 183 and then 184. Now, in what has been filed in this case, there is a current.
I can just tell you, if you put the degree already there and make it look like you already graduated, in the very end, you just say currently pursuing. What does that even mean? And for you to put that on there, it means you're like really close, I guess. That's the only way you could get by with it if you're in your last semester or maybe your last year at most. But if you're not even within your last year or it's not going to be completed within less than a calendar year, why would you put this? And currently pursuing is, I've never seen that before. That looks very evasive.
Currently pursuing at the end after University of Alabama - Birmingham, Alabama, correct?
Yes, that's correct.
Let's go back, please, to Exhibit 193. There is no currently pursuing there, is there, sir?
There is not, but that was filed in 2023. So that would be an expected graduation date of 2020.
Well, we're in 2025 now. So really, what happened? Why didn't you finish it in 2024? I think he's so far from even finishing it. Otherwise, he would say, yeah, I'm just two classes away. I'm just 3 classes. I'm going to finish it now this fall.
Before.
Okay, so this document was filed in 2023. However, there's nothing in this document that in any way leads the reader to believe anything other than the degree is obtained on 2024, correct?
Correct.
So the only way somebody in the court system or a judge or a jury would know anything about this is to have to know about court filing dates, correct? I'll ask it another way, Mr. Burgess.
That's hurting Hank's case here, so he needs to object.
You know how to write. Let's go back to 183 and 184. You know how to write currently pursuing on your CV, correct?
Correct.
And writing currently pursuing lets the reader know that you don't have that degree, correct?
Objection.
In that form, sustained.
You intend by writing currently pursuing, don't you, sir, that anybody reads this to know that you do not have a bachelor degree, correct?
Correct.
Now let's go back to what
Just so you know, Nick, I permanently blocked.
you filed in what was filed in federal court in that case.
I permanently blocked that. I don't want to say the word, but anyway.
And it does not have the words currently pursuing, correct?
It does not.
So the
Correct.
reader, it doesn't have that verbiage, correct?
Correct.
So isn't it the correct answer that you did file?
Of course, it's distracting. Absolutely. She doesn't care. Otherwise, she'd stop doing it.
A document, your CV, in this federal court case that
I mean, this guy act like he even cares that he lies on a resume. I mean, this guy it doesn't even phase him. Doesn't even phase him that he lies about the most important thing on your resume, which is a degree conferred by university. And he can't even, the fact that he doesn't even have the right degree that they're offering, I think he hasn't probably ever attended there in the last 10 years. But they're not asking that kind of question.
misstates the status of a Bachelor of Science in Mathematics and Business Administration.
Objection.
Sustained.
Excuse me, Your Honor.
Keep following up. Alessi, keep following up.
You stated again, sir, that you have not filed a document that misstates your educational background, correct?
So he basically lied in this court, and that's who they got. He lied coming into the court. He lied in other courts. He lied in federal courts. He said thousands of cases he's been working there. So he's lied in most of those apparently. And now he's going to lie here and just try to weasel out and blame some staff member or something. And yet he also just doesn't even seem like he cares. So how can this expert be considered anything but everything he says is completely tossed out? It actually should hurt the state. The state is hurt by having a guy that comes in there and just absolutely doesn't care one iota about being a fraud, quote unquote, expert on a case where somebody's facing a life sentence. And this guy doesn't even give a rip about that.
Correct.
Correct.
And the last time I'll cover it, you know how to put currently pursuing on anything to do with a Bachelor of Science, correct?
Correct.
Not enough complaints have been filed.
A Bachelor of General Science in Mathematics
changing.
and Business Administration does not exist as an offered degree at the
you go.
University of Alabama, Birmingham, does it?
Sure. So that is an error. Clearly, BGS stands for Bachelor's of General Studies, and that should have a with minor in Mathematics and Business Administration.
What
I don't even think he's that far close to any degree, because otherwise you would not have this kind of thing floating around out there. He's trying to throw in mathematics and science and business. It's such a lengthy description. It sounds so bogus on its face. And you allow this to happen?
is clear from that document that
What person has somebody else type up their resume in any office they're at? Who does it? This guy's in some high-ranking VIP at a company, some vice president, that somebody else, they have to update it, and they would make sure the information's accurate. If you're an expert, this is like so critical for you to have your resume more than anybody else, because you're going to get ripped apart, ripped to shreds like this guy is if you lie on anything about that. So you can't fudge anything on a resume as an expert, especially. Otherwise, you're toast. And you're telling me opposing sides aren't going to do a deep dive research on you? Apparently, there's been a lot. He's done mostly civil case where civil lawyers are not going to think that some guy's going to lie about his academic credentials. Working for a big company like Aperture.
BGS stands for a Bachelor of General Studies. What is clear in that document about the definition of that acronym?
That is a known acronym.
Let's go back to Bachelor of General Science in Mathematics and Business Administration. That degree does not exist. It is not offered at the University of Alabama, Birmingham, correct?
No, that is not.
So therefore, an incorrect statement about your educational background was filed in a federal court in Texas, correct?
Yes, it was.
That's it, Mr. Leslie? You
Yes.
done? Okay. Is there anything?
There is.
Okay.
The document that the attorney just showed you, did you submit that to the federal court?
No, I did not.
Did you ever?
Can you imagine? You have a bogus resume with this firm. You have it's on their website. You have a bogus CV on your LinkedIn account. I mean, and then they're trying to have this guy come off and say that no, he didn't know. It's everybody else. I mean, come on. Then that means he has so sloppy attention to detail. Nothing about him testifying here can be taken into account. Just dismiss everything he says. But you know what? It's even worse than that because the prosecutor having this bad of a witness will absolutely destroy your credibility. I mean, he's had nothing but destruction of his credibility in front of this jury day after day after day, hour after hour after hour. And yet this is the most damaging thing to the Commonwealth's case. And this was supposed to be one of their star experts. And then the other guy they're going to have come in is this Welcher guy. I wouldn't be surprised if this Welcher guy goes AWOL on him. I haven't researched, has this guy been on YouTube or any kind of things like that where he's testified before? I doubt it. And now he's going to be facing these kind of questions about this kind of guy working for him. Wow. Unreal. All right, so let's see. Hey, let's listen to
See that document before it was filed?
No, I did not.
The document says
Oh, right.
2024 for a degree. Is there a presumption whether you had it or expected it if that document was filed in 2023?
I just wish I would have asked him, what did you tell the prosecution about your academic credentials? Did you have the discussion? And why didn't he bring up the fact that he's pursuing? What does that mean? If he's pursuing it, it's relatively close and it's somewhat quasi-legitimate to have it on your CV, then why wouldn't Hank have asked him about that?
Yes, there is.
And what is the presumption if it was filed in 2023?
Objection, Your Honor. Respect.
So presumption,
Well,
we'll strike that.
okay. He asked if there was any designation to make it clear. If it says 2020, if it was filed in 2020,
They could have asked him, could you bring us your transcript? Can you obtain your transcript when you come back to testify to court tomorrow? I bet you wouldn't have showed up with one.
and it says 2024. What was your expectation at that time as far as your degree?
That I would complete my degree in 2024.
When you didn't complete your degree in 2024 as you expected, did you then change your CV
Yes, I did.
to accurately reflect the change in your status?
Yes, I did.
And what did you change it to?
Currently pursuing.
Why didn't you finish your degree in 2024?
Sure. So
Objection, Your Honor. Still.
No, I'm going to allow it.
Oh, why didn't he finish it? Okay, let's hear this one here.
As most people can probably relate, work, family, and life many times get in the way. So as a personal objective, I would like to finish my bachelor's, but again, work and life gets in the way.
Yeah, gets in the way. So when's the last time you completed a college course, Mr. Expert? How many decades ago?
Did you ever represent to a court that you had a degree that you didn't earn?
No, I have not.
He asked you a number of questions about this 2023 filing, but didn't ask you any questions about the data. Does your opinion regarding the data change in any way in light of his questions about a 2023 filing that you didn't file and someone filed on your behalf?
The objection is sustained. I'm going to strike that question.
They don't, I'm telling you, attorneys don't deal with low-level folks and businesses that hire experts. The experts are dealing directly with them. They're talking about them, and they interview them and go through their credentials, especially their academic credentials, because that's something they want to be able to impress the jury with. And granted, a bachelor's isn't going to impress them, but if that's all you got to make sure you got everything that's highlighted on that. And he's making this to be his best degree he's got. So you'd ask that, well, how close are you to graduating? So you're telling me that Hank, Mr. Detailed oriented guy, isn't going to ask him that?
No further questions.
All right, Mr. Burgess, you are all set.
Thank you.
Unbelievable.
Mr. Brennan?
I'd like to play a number of clips. If I could begin with clip 23.
This is overshooting a turn on the way to Fairview, turning around.
So we approach from the north, we actually missed the turn. And John says to me, it's Fairview, we just passed it, it's back there, it's on my left. I said, all right, so I pull nose into a driveway and back out onto the street, which I now own Cedar Crest, and then come from the north onto Fairview.
Like the next play, clip 25.
Okay, so that helps establish the 3-point turn, supposedly. So how is that damaging?
At 12:41, I leave a voicemail to John, where you can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage. And then you hear the car go off, and then you hear the sled ding, 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 as I open the door, shut the door. I had high heels on the night. You hear me walk in, go into the stairs up into the kitchen, shut the door. You hear me walk in the kitchen. It's like a full minute long. That's at 12:41.
Okay, and she got there at 12:36, and she also made multiple calls, and she probably was waiting for the garage door opener to work and get the garage door open, and then she gradually goes in at 12:41, gets out of the vehicle, or probably at 12:39, 12:40, then gets out of the vehicle, and is calling John at that time to leave a message, and he's not picking up. You can hear the high heels. So
And finally, clip 24.
So that's good for Karen.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. fine. So he died, we think he died right around 12:25, 12:30 on the early morning of January 29th.
Thank you.
Okay, I don't know why she said that they had been arguing. Remember, John was acting like he was not interested in Karen that morning of the 28th, that Friday morning. And then she's saying we think he died around 12:25, 12:30, early in the morning on the January 29th. So don't know why she came up with that time window of 12:25, 12:30. Because I think the evidence looks like he died much later than that. So I don't know where they came up with that. And that was in April of 2024. So that doesn't make any sense to me.
I have these for submission of evidence, Ron.
194. The next witness this time.
Yes, sir. I'm call Miss Christina Hanley to the stand.
All right. So this is Christina Hanley. She's another forensic scientist. She explained that the trace arson explosive unit examines trace items such as paint, glass, fibers, hair, tape, miscellaneous items, serial number restorations on firearms. And they didn't get a chance to cross her. She just went into some of the stuff she looked for physical match comparisons. So I'll just stop that at now, and then we can cover tomorrow night what the cross was. Yeah, I think that's the only reason he did this updating of it to say currently pursuing is because he knew this was going to be posted for the World Wide Web to see. Yeah, this is I don't know if they're going to get it wrapped up this week because if they call this Welcher guy, that's going to be 2 days right there. We're already Tuesday, Wednesday, Thursday is half day. So I don't see them wrapping it up this week at all. Plus they got the dog, so-called dog expert Crosby, dog bite expert. So anyway, I'll go ahead and take questions now. Let's see. All right, I just tried to post a question and it's not showing up. Julia Nielsen, what's the quickest criminal verdict you've seen? I've seen one that's like about 5 minutes. It was a case I was a defense counsel on, and it was an open and shut case. It was a domestic violence case. And yeah, it was like 5 or 6 minutes, not guilty. Okay, Nick, you're saying Crosby won't testify. Okay, yeah, he's going to rebut the experts for the defense. That's true. Thanks for pointing that out. But if they wanted to, they could call him now. But I guess they're going to wait in rebuttal. They're not really trying to explain away a whole lot of stuff. I don't think they're going to call any of the other folks in the House. Nor, I don't think he's allowed to watch any other testimony. But experts normally can watch experts, and they've already shared information. So it all depends what the attorneys want to have set up as an arrangement. Normal witnesses you can't, but experts, because experts can review each other's work and compare and try to impeach the work of the other. Hey, that's interesting. You're saying Your uncle works for the feds here in Massachusetts. He said the feds are watching closely and not announced case closed. Well, that's what I've been saying all along, just by speculation. I mean, the corruption hasn't ended there in Massachusetts, so why would the feds stop investigating? Yeah, Britt Chick, you're saying they have the dog bite expert, the neurosurgeon, and Welcher. So, yeah, and if the dog bite expert's on rebuttal to the defense's case, so you're just looking at two witnesses. Yeah, they're not going to get through this cross-examination this week. So it is going to be maybe early middle of next week. And let's see. Well, and then next Monday we have, I think that's a federal holiday, right? So it's going to be next Tuesday. So yeah, it'll be by the end of next week. They should be wrapped up. Yeah, her whole demeanor is just very extremely troubling. She's not taking this case seriously. The amount of smiling she's doing and all these mannerisms are just very, very troubling. And you don't have a judicial persona going on here. The demeanor is not fitting for a judge, especially one on a murder case. Fierce like Frida, do I think Brandon will use Welcher for Commonwealth rebuttal? I mean, he could do that as well as with the dog bite guy, but I don't think he will. But it's always a possibility. We know for sure the defense is going to call their experts, so that could be a strategic move to do that. But I think they'll probably call him still under case in chief. I've never had a verdict that I was shocked with. I've seen that on other cases, but not my own. Generally, I just trust. I think if you get the right aggressive defense attorneys on the case, you're not going to have a problem with jurors. When folks say, "Well, you never know what a jury is going to do," any attorney that says that, a trial attorney, I just think, well, you should be able to present your case and be persuasive enough as an advocate to have the jury do the right thing. So I just look at that as an inexperienced attorney or non-effective attorney that says that. Little Miss Red Velvet, what are my thoughts about repercussions for the judge after this trial? I mean, I don't think they really care about this kind of stuff up there. You know, they're all in tight, they're all connected politically. So, you know, I'm hearing about all these complaints are now up there against this judge filed with the Judiciary Commission, and the numbers may help do something, but I don't think you're going to see her removed from the bench at all. Yeah, so Nick Rocco's doing he runs that platform for the funding for supporting the defense team, Karen Reed and their defense team. So don't give money on this channel. I don't want any super chat money. Please give it all to Karen Reed and her team. If you're inclined to give me something, please don't. Just give it to their team instead. Let me see. I'm going to exit this. Oops. Where did that screen go? Oh my gosh. I got the. All right. My mouse is acting up. Sorry, guys. All right, let's see. Exit full screen. Okay, there we go. Trailgazer, you don't understand what the behavior of these corrupt people because you're not corrupt. You can't believe the behaviors are so blatant. They don't seem to care that the world's watching. Yeah, that's what's really surprising. Normally, folks would be more against being exposed like this for the world to see, but Archie Cat, they've yet to prove an officer John O'Keefe was murdered or hit by a vehicle. Instead, they're proving themselves liars, deceitful, and manipulative. Yeah, that sums it up pretty good. I've not seen it secretly done with code type of signals like they're doing with between each other, Brennan and the judge. I've had a judge openly tell the prosecutor how to do better on a case that I was on when I was the defense counsel. Yeah, I'm not, Sandy, I'm not going to get into whether people can sue them or whatever. I don't know if this guy has been involved in that big of cases. And they're already settled and done. So I mean, getting a lawsuit for that because he has a bogus academic degree listed on his CV. If you're testifying in front of a judge or a jury, I mean, that's a huge deal. Julia, I've never seen that before. This is very unique. I think there's only a few states that do it in the Northeast, from what I've heard. I think it's a good way to help get the outcome you want if a judge wants to put their weight on the scales of justice. No, she's got judicial immunity. Asking Lally if you'd like to object, that's not going to take away that protection. Kate, you're saying if the defense's expert had false credential, would judge typically do anything? I think that she'd probably say it's like a Rule 14 violation or something like that if it wasn't disclosed. But of course, on this case, he disclosed it, and but he hadn't before. So maybe him talking to Brennan's the only reason he put that in there and gave it to defense, but he didn't do the follow up and start correcting it on his website, his LinkedIn. And of course, there's a trail in a history of him giving out false representations. So normally let's say if this comes out in cross-examination, so you don't have to have a degree to be an expert on a case to have the expertise. So his kind of line of work would allow him to have that kind of expertise to be able to testify as an expert per se, and if he's going to lie about something on his resume, I think that's just for the jury to decide his credibility. I don't think a judge is going to keep him out for that reason. I'm just saying, as a prosecutor, if I knew somebody lied on a resume, I would never have that person testify. I would not want that kind of stink coming into my case. Yeah, notice how Brennan blocked that kind of questioning from coming out about his bogus certifications and bogus degree is going to have a detrimental impact for people paying their insurance premiums. Lori, you're saying you saw another channel, 80 for 95% of watchers saw Karen, thought Karen is not guilty and the corruption on is rampant in Canton. Yeah, I don't know if any of that polling is correct. Yeah, I'd want to see what he's been doing and when for the last 10 years. Crisis Truth, I think Karen said 2020 025 0030 because that's what she was being told. I mean, yeah, all that kind of stuff. She's talking to her defense attorneys ahead of time. I don't know why they thought that was a time window back then, but I think they got a lot better. They got a lot better on the details, the forensic details, the medical details, and the physics details this time around. Keep in mind, they also didn't have time to prep with ARCA beforehand. Now they do. As I understand it, it's just like the first juror number one is automatically the foreperson. So I don't know how much the judge picks it per se, but not sure about how that all works up there. I just think it lends itself to very much unfair process for litigants. Hannah Bell, you're saying you heard the judge was supposed to rotate and can only change up the rotation so to get the case again. I'd heard something like that too. I'm not sure if that's true, but I can see that happening if she was supposed to be off the case. Lisa, if she pleads, it'll end. If she fights, there'll be an episode. Why would you have that conversation? That's what Matt McCabe said in a text message. Why would you say that there would be an episode? Meaning he was worried about that. He's worried about her not taking the fall for this murder. And if you say it's an episode, it makes it sound like you're going to be involved in that episode, right? Like you're going to be worried about it. Why would you be worried about whether she pled out or not? Cabo Girl, you're saying, I hope this jury doesn't regret a bad decision after watch this trial and replay. I don't want someone to wish they voted not guilty. That's why in my closings, I hammer home and I bring it out in jury selection also that they need to have all their doubts here in the jury deliberation room. They cannot go home. They cannot be pressured. I bring up the fact that there was a case on like a Dateline or 2020 back in the 90s where somebody was on a jury and they were a business owner and they were busy trying to manage both that and their jury duty, and they just went with the flow. And when they got home that night, they couldn't sleep because they realized that they voted wrong. They voted for a conviction. And then they went back to the courthouse and told the judge. They went actually to the judge's chamber saying, I want to change my vote. The judge said, sorry, too late. They went to the district attorney. The district attorney said, sorry, you can't change your vote. This person still couldn't sleep. So they wound up talking to a defense lawyer, and the defense lawyer says, well, if you hire me, I can fight it on appeal. So this business person wound up spending 25 grand of their own money to fight it on appeal just to clear their conscience. So I always bring up that story to make sure that they don't have those same nightmares. So I remind the jury in my closing that they can't be like this other person we talked about in Voir Dyer, where you're going to be haunted and have these nightmares And who can afford to hire a lawyer to defend somebody nowadays anyway? Well, I think you're asking Brit Chick, suspicious judge wanted more alternates time around. Maybe she didn't have her fix in place. No, I don't. I just think it comes down to when you have so many different reasons people cannot be available for jury duty. A lot of people don't like to be called for jury duty. They think it messes with their lives. I think it's one of the most honorable things you can do as a U.S. citizen. I've never been called to jury duty at all. I would love to have that opportunity, but also me as a lawyer, I don't think anybody would want me as a as a as a juror. I would have too much influence on the jury is what they'd be worried about. Sandy, I've come up against prosecutors that have done shady, unethical things. I'm not going to talk about Brendan's ethics here, but I'm going to say that I've seen attorneys do shady and unethical things numerous times. And so it's far more common than you can imagine. Legal feeling, she chose to stay on the case beyond her regular rotation. She has an option for the retrial. That, I like I said, I can't confirm that or not. I don't know how you'd know that detail. Was that reported in the news or something? Yeah, the attorney, they're hiding something totally shady and illegal. There's no other explanation. Even if they had nothing to do with John's death, they're hiding something felonious. That's what I'm saying. Who cares about third party culprit naming anybody, whatnot? I mean, I think the jury figures out there's something extremely shady, way more than in the first trial. What's going on of those people in the house, especially Higgins now. Linda Mon, the signaling going on between Brendan and Judge Canoni. I've not seen that today. If you can give me a timestamp for that, I'll go back to it. Oh, yeah, that's something. All right, let me go back to that here. I'm going to show one of these. Here, let's go to this one here. This has to do with Higgins. From Microdots. Let's check this out here. Just 14 minutes.
Sometime before 1:26 a.m. Brian Higgins walks outside, gets into his Jeep. Never sees the body of a man over 6 feet tall lying directly beneath the flagpole. despite it being illuminated by the powerful plow lights mounted on the front.
Look how good the graphics are on this. This is amazing. Look how realistic all that is.
No sneaker, no shards of reflective plastic on the road in front of him. Brian Higgins then drives away from 34 Fairview Road.
That's amazing detail.
It's 1:26 a.m. We will first see Brian Higgins arrive to the police station as viewed from the rear parking lot camera. It is mounted on the back corner of the Sallyport garage. The red circle represents where he parks. He exits the vehicle. The surveillance video picks up his iPhone's true depth facial ID camera, scanning his face. This means he's looking directly into his device. He hesitates momentarily, looks back at the Jeep, looks into his phone, then continues. While he's outside, Brian will be using his phone quite a bit. Next, we see him pass in front of the small island containing a tree and a light pole. The camera is mounted here. He walks to the entry on the church side of the Sallyport and is picked up by the camera at the top corner of the main building. At 1:28, he walks down the first floor corridor. He enters this room for 1 minute and 39 seconds before returning to the hallway. This door leads to the communications center. Here's how we know. The camera we are viewing from is located here. We can trace his steps through the interior of the police station, entering the first floor corridor and then moving directly to the comm center. The comm center is manned at all hours. It would be the first place you'd go to find out if anything unusual has been reported, like a woman calling to say she dropped her boyfriend off at a party and hasn't heard from him since. And it's just on the other side of that glass. We attempted to decipher the words written on this sign.
Why would he go to the comm center?
I believe it reads authorized personnel only. He takes a quick look down the hall, perhaps to see if anyone is present.
ATF agent going into the comm center? Why would you care to go there?
Then takes a right and moves out of view of the
This is like 1:30ish in the morning.
cameras. From here, he could have taken one of 3 doors. To his left and right are offices. Straight ahead is an entryway which leads to the front wing of the building, with also a stairwell that he could have taken to go upstairs to the second floor. Here's the second floor layout. If he did come up here, he would have exited the stairwell at this point, and based on the timeline, he certainly had the time to do it. The station seems to have numerous cameras in place inside and out. It's peculiar then that the exact footage that would show us where Higgins went for those crucial minutes is conspicuously missing. Are we really expected to believe there are no security cameras operating inside the communications center, the very place where police interact with the public face-to-face through glass every day? and not a single other camera in the building that could
No, Kevin Albert was a detective. Detectives don't work at a comm center.
show us where Brian Higgins went. These officials have proven their willingness to tamper with and withhold crucial evidence. Therefore, it's just as important to consider what was not provided as it is to examine what was. 4 minutes and 36 seconds later, he reappears in the main corridor and proceeds to leave the same way he came in. He just reached into his pocket for his phone and now has it in hand. But he waits. The second he steps outside of the building, he starts using his phone again. It's already up to his ear. It's worth noting he stayed off the phone while inside, at least from what we can see, meaning he likely placed a call as soon as he had privacy again. Higgins enters frame right and approaches the Jeep, still with the phone to his ear. He walks between the Jeep and the large pickup and heads straight for the vehicle in the rear of the parking lot. We know this because we see his long shadow moving that way behind the Jeep. Higgins stands outside the vehicle briefly.
That's really hard to see, but does that vehicle move
Then
forward?
opens the door and gets
Yeah,
inside.
there you see the door opening. Okay.
The tail light
Car goes
illuminates,
forward. There you go.
indicating he starts the vehicle. It is located approximately here. He first turns on the windshield wipers, then rolls the driver's side window down to clear snow, allowing him to see. We speed up the playback while he sits inside. He moves the vehicle off screen left. He reappears and clears both windshield wipers from a third vehicle.
That's what I thought is suspicious too. What guy has a hood up while indoors?
He stops here with his elbows bent as they would be if he was manipulating his phone in front of him, in a stance consistent with interacting with text messaging. He focuses on his device for about 18 seconds, then proceeds to the rear of the Jeep. And returns to open the driver's side door, most likely to fetch the keys for the large truck, a fourth vehicle, which lights are triggered as he remotely unlocks it, then enters to start the engine. The lights flicker again when he opens the door.
So even if he moved a vehicle, why would he move a vehicle? What purpose does that serve? There's no reason you'd want to move a car, because either way, any place you move it, you're going to be blocking some snowplow from getting there.
The truck is now on and idling, with the driver's side door still slightly open. He rolls the vehicle forward a few feet, deeper into the parking spot. He opens the passenger side door of the third vehicle, reaches in. then walks back to the Jeep. And seems to do the same thing there, opening the door momentarily. Then back to the third vehicle he goes, this time to access the bed. We see the black underlid of a container or tarp come up and cover the back window momentarily. He reaches in, throws a large duffel bag over his shoulder, and closes the lid. The bag appears to be very large.
Yeah, it does.
He opens the driver's side door of the Jeep. Again, you get a clear glimpse of just how massive the bag is. He walks to the back of the Jeep and places it inside.
Yeah, that's what it's looking like. Why didn't he mention he grabbed a bag then in his testimony? Yeah, it's not deep at all, the snow yet.
Then starts up the vehicle and closes the door. Returning to the third vehicle, he opens the passenger side door. He's looking for something towards the back seat. He opens the rear passenger side door and looks in. He then walks off camera, left side momentarily. He is presumably on the other side of the vehicle, rear door.
Not sure about that.
He returns to the Jeep yet again to do something. Then heads back to the third vehicle.
A lot of moving around. It's about 2 a.m. now. They didn't know about this video. This wasn't given to the defense at the first trial. Which is a Brady violation. This case should have been dismissed for that reason alone.
We see him walk back into frame, this time holding some kind of poled tool, possibly a snow brush. However, he doesn't use it on any of these vehicles.
Yeah, so he's saying he moved cars. So I guess he's got an out with that, but he's doing a lot of other stuff that's even more suspicious than saying he went there to move cars.
He puts it inside the Jeep, gets in, and readies to leave the premises. And finally, he drives off into the night. All we know about what he did next is what he's told us.
Is that not suspicious or what? All right, let me shut this off. So what's your guys' take on that? I think how they were able to enhance this, I don't know how they do that, but wow, that's really amazing. Yeah, some folks are saying it's a Faraday bag. Yeah, where's the rest of the video from inside the police station? That's a pretty big duffel bag there. Yeah, it hasn't come out what that vehicle was. That looked like a four-door pickup with a back topper on it. Yeah, I can imagine a Faraday bag would be that big. So then that butt dial was happening. So that what is that? 12:20-ish, 12:22. I think that butt dial in started going on between him and Brian Albert. Faraday bag. The point being that if they're going to move John O'Keefe and his phone, then to keep the phone from showing up as being moved, goes a different spot, like inside the house, and you put it in a Faraday bag, then move the body to his final spot where he was found at 6:04, where John O'Keefe's body was found at 6:04. All right, so I'm just looking for a final last question here, and I'm going to sign off. Yeah, so microdots, if you guys haven't seen them, definitely check them out. Including this one here. Microdots video, the bar when everyone leaving shows Brian angrily shouting at John. That's what it can appear to be. Alberts confer with Kevin before leaving. Karen is busy talking. John is paying his bar tab. Yeah, did I say that wrong? 2:22, not 12:22. Thanks for correcting me. All right, with that, I'm going to go ahead and sign off. It is, what is it, midnight again here in Texas. So I'm going to go ahead and sign off, folks, and hope to be back on tomorrow night. But today, to sum it up, is another explosive day of impeachment on the star witness from Aperture. And we're going to have more evidence coming out. And I think the state's case is just going to be the same stuff day after day. We're not going to see anything getting any traction to show Karen Reed's guilty. It's nothing but blow-ups in the government's face, including reasonable doubt after reasonable doubt. There's so many reasonable doubts in this case, dozens and dozens and dozens of them. So with that, I'm going to go ahead and sign off tonight. You all take care. Have a good night.